any witness, any attorney, any defendant, any alleged victims, based on any disability or gender or nationality or national origin, race or ethnicity, religion, age, or socioeconomic status. Also, as we discussed with you at the very beginning of jury selection, it is your responsibility to accept and follow and apply the law that I'm now going to give to you, even if you disagree with some of those principles of law. If you believe that any of the attorney's comments in their closing arguments or at any other time during the trial conflicts with my instructions on the law, then of course you must disregard their comments and base your decision solely on my instructions. Obviously, you should pay careful attention to all of the instructions and consider them together as a whole. If any instruction seems to be repeated or stated in different ways, do not conclude that it is any more important than any other instruction just because it seems like it's being repeated. There may be some words or phrases that have a specific legal definition that may be different from the common everyday meaning. If there are any words or phrases that do have specific legal definitions, I will give you those definitions in these instructions, and then of course you must apply them. Any words or phrases that I do not specifically define for you should be applied using their ordinary everyday meaning. Some of the instructions that I give you now may not apply, depending upon what you find to be the facts. Do not assume that just because I give a particular instruction that I am suggesting anything about the facts. I am not. After you have decided what the facts are, then follow the instructions that do apply to the facts as you determine the facts to be. And a reminder, do not use your computers, cell phones, internet, social media, any reference materials in doing any additional research. Everything you need to resolve the case, you heard as evidence here, or the instructions that I'm now going to give you. Do not investigate the facts or the law, and do not do any research on your own regarding the case. Do not conduct any tests or experiments or visit the scene of any of the events involved in the case. If you happen to pass by some of the scenes that have been mentioned, do not stop and investigate. A reminder about your notes. You've been given notebooks. I know most of you have taken notes. Of course, you can use your notes during your deliberation. Just a reminder that your notes are only for your own individual use to help you remember the testimony during the trial. Keep in mind that a person's notes can be inaccurate or incomplete, just as someone's memory can be inaccurate or incomplete. If there is a disagreement about particular testimony at trial or particular evidence at trial, you can ask the court reporter to go back through her record, find that part of the evidence, and read it back to you. And if that occurs, of course, the court reporter's official transcript must prevail over anyone's notes or memory. You must accept the court reporter's record as accurate. Do not remove your notes from the jury room. So if you noon recess, evening recess, do not take your notes with you. Leave them in the jury room. They'll be safe there. It is alleged that the crime in this case occurred on or about February 4th, 2010. The people are not required to prove that the crime took place exactly on that day, but only that it happened reasonably close to that day. A trial is not a contest between the attorneys. Rather, a trial involves the evaluation of the evidence in the case by you, the jurors, and your determination of the convincing force of the evidence, regardless of your perception of any of the attorneys. Evidence is the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you that you can consider as evidence, such as any stipulations between the attorneys. Nothing that the attorneys say is evidence. In their opening statements and their closing arguments, the attorneys can discuss the case, but their comments are not evidence. This is particularly important in a lengthy case such as this. The attorney's opening statements were nearly 5 months ago. Some witnesses or information discussed in opening statements may not have been presented as evidence. Other witnesses may have testified differently than originally anticipated. So when evaluating the evidence, it is important to only consider the actual evidence that was presented. Also, the attorney's questions are not evidence. Only the witness's answers or testimony is evidence. The attorney's questions are significant only if they help you to understand the witness's testimony. Do not assume that something is true just because one of the attorneys asked a question that suggested that it might be true. During the trial, the attorneys may have objected to questions or moved to strike answers given by some of the witnesses. I rule on those objections according to the law. If I sustain an objection, you must ignore the question. If the witness was not permitted to answer, do not guess what the answer might have been or why I ruled as I did. If I ordered testimony stricken, you must disregard it and not consider that testimony for any purpose. You also must disregard anything that you saw or heard when the court was not in session, even if it was done or said by one of the parties or witnesses. During the trial, you were told that both the people and the defense agreed or stipulated to certain facts. This means that both sides accepted those facts as true. Because there is no dispute about those facts, you also must accept any stipulated facts as being true. Again, the court reporter has made a record of everything that was said during the trial. If you decide that it is necessary, you can ask the court reporter's record be read back to you. And then, of course, again, you must accept the court reporter's record as accurate. Facts may be proved by either direct or circumstantial evidence, or by a combination of both. Direct evidence is evidence that directly proves a fact by itself. For example, if a witness testified that he saw it raining outside the courthouse before he came into the courthouse, that testimony would be direct evidence that indeed it is raining outside. Circumstantial evidence can also be called indirect evidence. Circumstantial evidence does not directly prove the fact to be decided, but is evidence of another fact or group of facts from which you may logically and reasonably conclude the truth of the fact in question. For example, if a witness testified that he saw people coming inside the courthouse wearing raincoats and carrying umbrellas with drops of water on them, that testimony may be circumstantial evidence because it may support a conclusion that it must be raining outside. Both direct and circumstantial evidence are acceptable types of evidence to either prove or disprove the elements of a charge, including any intent or mental state, and any acts necessary to a conviction. Neither direct nor circumstantial evidence is necessarily more reliable than the other. Neither is entitled to any greater weight than the other. You must decide whether a fact and issue has been proved based upon all of the evidence. However, before you may rely on circumstantial evidence to conclude that a fact necessary to find a defendant guilty has been proved, you must be convinced that the people have proved each fact essential to that conclusion beyond a reasonable doubt. Also, before you may rely on circumstantial evidence to find a defendant guilty, you must be convinced that the only reasonable conclusion supported by the circumstantial evidence is that the defendant is guilty. If you can draw two or more reasonable conclusions from the circumstantial evidence, and one of those reasonable conclusions points to innocence, and the other to guilt, you must accept the one that points to innocence. However, when considering circumstantial evidence, you must accept only reasonable conclusions and reject any unreasonable conclusions. Also, as we discussed at the beginning of the trial, you alone are the judges of the credibility or believability of the witnesses. In deciding whether testimony is true and accurate, use your common sense and experience. You must judge the testimony of each witness by the same standards, setting aside any bias or prejudices that you may have. You may believe all, part, or none of any witness's testimony. Consider the testimony of each witness and decide how much of it you accept. In evaluating a witness's testimony, you may consider anything that reasonably tends to either prove or disprove the truth or the accuracy of their testimony. Among the factors that you may consider are the following. How well could the witness see, hear, or otherwise perceive the things about which the witness testified? How well was the witness able to remember and describe what happened? What was the witness's behavior while testifying? Did the witness understand the questions and answer them directly? Was the witness's testimony influenced by a factor such as bias or prejudice, or a personal relationship with someone involved in the case, or a personal interest in how the case is decided? What was the witness's attitude about the case or about testifying? Did the witness make a statement in the past that is either consistent or inconsistent with their testimony here at trial? How reasonable is the testimony when you consider all of the other evidence in the case? Did any other evidence tend to prove or disprove any fact about which the witness testified? Did the witness admit to being untruthful about anything? Do not automatically reject testimony just because of some inconsistencies or conflicts. Rather, you should consider whether the differences are important or not. People sometimes honestly forget things or honestly make mistakes about what they remember. Also, two people may witness the same event, yet see it or hear it differently. If you do not believe a witness's testimony that they no longer remember something, that testimony then is inconsistent with the witness's earlier statement on that subject. If you decide that any witness deliberately lied about something significant in this case, you should consider not believing anything that that witness said. On the other hand, if you think that the witness did lie about some things, but nevertheless did tell the truth about others, you may simply accept the part that you think is true and ignore the rest, or reject the rest. Neither side is required to call all witnesses who may have any information about the case or to produce all physical evidence that might be relevant. The testimony of any single witness can prove any fact. Of course, before you conclude that the testimony of any single witness does prove a fact, you should carefully review all of the evidence. If you determine there is a conflict in the evidence, you then must decide what evidence, if any, to believe or accept. Do not simply count the number of witnesses who agree or disagree on a point and then accept the testimony of the greater number of witnesses. On the other hand, do not disregard the testimony of any witness without a reason or because of prejudice or because of a desire to favor one side as against the other. What is important is whether the testimony or the evidence convinces you, not just the number of witnesses who testified on a certain point. During the trial, certain evidence was admitted for a limited purpose. You're reminded that you can only consider that evidence for the limited purpose that it was admitted for. You have heard evidence of statements that some of the witnesses made before the trial. If you decide that the witness did in fact make those statements, you may use those statements in two ways. One, to evaluate whether the witness's testimony in court is believable, and two, as evidence that the information in those earlier statements is in fact true. Some witnesses were allowed to testify as expert witnesses and to give certain opinions or expert opinions. You must consider those opinions, but you are not required to accept them as true or correct. The meaning and importance of any opinion is up to you to decide. In evaluating the believability of an expert witness, follow the instructions about believability of witnesses generally. In addition, consider the expert's knowledge, skill, experience, training, and education, the reasons the expert gave for any opinion, and the facts or information on which the expert relied in reaching that opinion. You must decide whether information on which the expert relied was true and accurate. You may disregard any opinion that you find to be unbelievable, unreasonable, or unsupported by the evidence. An expert witness can also be asked what's known as a hypothetical question. In a hypothetical question, the expert witness is asked to assume to be true certain facts, and then asked to give an opinion based upon those assumed facts. It is up to you to decide whether those assumed facts have in fact been proven by the evidence. If you conclude that any of those assumed facts are not true or have not been established by the evidence, you should consider the effect of that on the expert's reliance on those facts in evaluating the expert's opinion. If expert witnesses disagreed with one another, you should weigh each opinion against the other. You should examine the reasons given for each opinion and the facts or other matters upon which each witness relied. You may also consider the expert's qualifications. Other witnesses who were not expert witnesses may have also given certain opinions during the trial. Again, you may but are not required to accept those opinions as true or correct. You may give those opinions whatever weight you think they're entitled or is appropriate. Consider the extent of the witness's opportunity to perceive the matters upon which their opinion is based, the reasons the witness gave for any opinion, and the facts or information on which the witness relied in forming that opinion. You must decide whether information on which the witness relied was true and accurate. You may disregard all or any part of an opinion if you find that the opinion is unbelievable, unreasonable, or unsupported by the evidence. A defendant has an absolute constitutional right not to testify. He may rely on the state of the evidence and argue that the people have failed to prove the charges against him beyond a reasonable doubt. Do not consider for any reason at all the fact that Mr. Merrick did not testify. Do not discuss that fact during your deliberations. Do not let it influence your decision in any way. You have heard evidence that the defendant made oral or written statements before the trial or while the court was not in session. You must decide whether the defendant made any of those statements in whole or in part. If you decide that the defendant did make those statements, you can consider those statements along with all of the other evidence in reaching your verdict. It is up to you to decide how much importance to give to those statements. A defendant may not be convicted of any crime, however, based solely on his out-of-court statements. You may rely on the defendant's out-of-court statements to convict him only if you first conclude that there is some other evidence that shows that the charged crime was committed. The other evidence may be slight and need only be enough to support a reasonable inference that a crime was committed. This requirement of other evidence does not apply to proving the identity of the person who committed the crime and the degree of the crime. If there is some other evidence that shows that a crime occurred, the identity of the person who committed it and the degree of the crime may be proved by a defendant's statements alone. You may not convict a defendant unless the people have proved his guilt beyond a reasonable doubt. The people are not required to prove that the defendant had a motive to commit the crimes charged. In reaching your verdict, you may, however, consider whether the defendant had a motive. Not having a motive may be a factor tending to show that a defendant is not guilty. Having a motive may be a factor tending to show that a defendant is guilty. However, having a motive cannot prove guilt by itself. If the defendant tried to create false evidence or obtain false testimony, that conduct may show that he was aware of his guilt. If you conclude that the defendant made such an attempt, it is up to you to decide its meaning and importance. However, evidence of such an attempt cannot prove guilt by itself. The fact that a criminal charge has been filed against the defendant is not evidence that the charge is true. You must not be biased against the defendant just because he's been arrested, charged with a crime, or brought to trial. A defendant in a criminal case is presumed to be innocent. This presumption requires that the people prove a defendant guilty beyond a reasonable doubt. Whenever I tell you that the people must prove something, I mean that they must prove it beyond a reasonable doubt, unless I specifically tell you otherwise. Proof beyond a reasonable doubt is proof that leaves you with an abiding or lasting conviction that the charge is true. The evidence need not eliminate all possible doubt, because everything in life is always open to some possible or imaginary doubt. In deciding whether the people have proved their case beyond a reasonable doubt, you must impartially compare and consider all the evidence that was received throughout the entire trial. Unless the evidence proves the defendant guilty beyond a reasonable doubt, he is entitled to an acquittal, and you must find him not guilty. Homicide is the killing of one human being by another. Murder is a type of homicide. The defendant is charged with murder. I will now instruct you on the different types of murder and the requirements that must be proven to establish each type of murder. The defendant is charged in counts 1 through 4 with the crime of murder in violation of Penal Code Section 187. In order to prove that the defendant is guilty of the crime of murder, the people must prove each of the following elements beyond a reasonable doubt. 1, the defendant committed an act that caused the death of another person. And 2, when the defendant acted, he had a state of mind called malice aforethought. The defendant acted with express malice if he unlawfully intended to kill. Malice aforethought does not require hatred or ill will toward the victim. It is a mental state that must be formed before the act that causes death is committed. It does not require deliberation or the passage of any particular period of time. An act that causes death, if the death is the direct, natural, and probable consequence of the act, and the death would not have happened without the act. A natural and probable consequence is one that a reasonable person would know is likely to happen if nothing unusual intervenes. In deciding whether a consequence is a natural and probable consequence, consider all the circumstances established by the evidence. If you decide that the defendant committed murder, it is murder of the second degree unless the people have proved the additional requirements for first-degree murder. And I will now give you the requirements for first-degree murder. A defendant is guilty of first-degree murder if the people have proved that he acted willfully, deliberately, and with premeditation. A defendant acts willfully if he intended to kill. A defendant acts deliberately if he carefully weighed the considerations for and against his choice, and knowing the consequences, decided to kill. The defendant acted with premeditation if he decided to kill before completing the acts that caused the death. The length of time that a person spends considering whether or not to kill does not alone determine whether the killing is deliberate and premeditated. The amount of time required for deliberation and premeditation may vary from person to person and depending upon the circumstances. A decision to kill made rashly, impulsively, or without careful consideration is not deliberate and premeditated. On the other hand, a cold, calculated decision to kill can be reached quickly. The test is the extent of the reflection, not the length of time. The people have the burden of proving beyond a reasonable doubt that the killing was first-degree murder rather than second-degree murder. If the people have not met this burden, you must find that the murder was not first-degree and that the murder was second-degree. For each count charging murder, you will be given verdict forms, and you're going to have these verdict forms in the jury room, so you don't need to take copious notes on these verdict forms. You'll be given verdict forms on each count of either guilty of first-degree murder, guilty of second-degree murder, or not guilty. You may consider these different types of homicide, first and second-degree murder, in whatever order you wish. But the court cannot accept a verdict of guilty of second-degree murder unless you have all found the defendant not guilty of first-degree murder. As with all the charges in this case, in order to return a verdict of guilty or not guilty on any count, all 12 jurors must unanimously agree to that decision. Follow these directions before you give me any completed or signed final verdict form. You will complete and sign only one verdict form for each count. Return the unused verdict forms to the court as well. If you all agree that the people have proved beyond a reasonable doubt that the defendant is guilty of first-degree murder, complete and sign the verdict form of guilty of first-degree murder. Do not complete any of the other verdict forms for that count. If you cannot agree whether the defendant is guilty of first-degree murder, inform me only that you cannot reach an agreement and do not complete any verdict form for that count. If you all agree that the defendant is not guilty of first-degree murder, but also agree that the defendant is guilty of second-degree murder, complete and sign the form for guilty of second-degree murder. Do not complete or sign any other verdict forms for that count. If you all agree that the defendant is not guilty of first-degree murder, but cannot agree whether the defendant is guilty of second-degree murder, inform me that you cannot reach an agreement on that count, and then do not complete any verdict forms for that count. If all of you agree that the defendant is not guilty of first-degree murder and not guilty of second-degree murder, complete and sign the verdict form for not guilty. Do not complete or sign any other verdict forms for that count. The crimes charged in this case require proof of the union or joint operation of both an act and wrongful intent. In order for you to find a person guilty of the crimes charged in this case, that is murder, a person must not only intentionally commit the prohibited act, but must do so with a specific intent or mental state, malice aforethought. Both the act and the specific intent and mental state that are required are explained in the instructions for the crime. The people must prove not only that the defendant did the acts charged, but also that he acted with a particular intent or mental state. The instruction for each crime and allegation explains the intent or mental state that is required. An intent or mental state may be proved by circumstantial evidence. However, before you may rely on circumstantial evidence to conclude that a fact necessary to find the defendant guilty has been proved, you must be convinced that the people have proved each fact essential to that conclusion beyond a reasonable doubt. Also, before you may rely on circumstantial evidence to conclude that the defendant had the required intent or mental state, you must be convinced that the only reasonable conclusion supported by the circumstantial evidence is that the defendant had the required intent or mental state. If you can draw two or more reasonable conclusions from the circumstantial evidence, and one of those reasonable conclusions supports a finding that the defendant did have the required intent or mental state, and another reasonable conclusion supports a finding that the defendant did not have the required intent or mental state, you must conclude that the required intent or mental state was not proved by that circumstantial evidence. However, when considering circumstantial evidence, you must accept only reasonable conclusions and reject any unreasonable conclusions. If you find the defendant guilty of first-degree murder, you must also decide if the people have proved that the special circumstance alleged in this case is true or not true. The people have the burden of proving the special circumstance beyond a reasonable doubt. If the people have not met this burden, you must find the special circumstance has not been proved. You must return a verdict form stating either true or not true for the special circumstance. In order to return any finding, all 12 jurors must agree unanimously to the decision. The defendant is charged with the special circumstance of having been convicted of more than one murder in this case. In order to prove this special circumstance is true, the people must prove the following. 1, the defendant has been convicted of at least one charge of first-degree murder in this case, and 2, the defendant has also been convicted of at least one additional charge of either first or second-degree murder in this case. So obviously you can't reach that decision until you've decided either guilty or not guilty of the underlying charges. In your deliberations, you may not consider or discuss penalty or punishment in any way when deciding whether a special circumstance or any other charge has been proved or not. The people must prove that the defendant committed murder. The defendant contends he did not commit this crime and that he was somewhere else when the crime was committed. The people must prove that the defendant was present and committed the crime with which he is charged. The defendant does not need to prove he was elsewhere at the time of the crime. If you have a reasonable doubt about whether the defendant was present when the crime was committed, you must find him not guilty. Each of the counts charged in this case is a separate crime. You must consider each count separately and return a separate verdict for each count. There is a concluding instruction that I will give to you after the attorney's closing statements. We'll take about a 10-minute recess, give everyone a chance to stretch after that very dramatic reading of the jury instructions. Keep in mind the admonitions previously given to you, not to form or express any opinions about the case, not to discuss the case, and we'll see everyone back in about 10 minutes.